There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide first-hand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
Today's courtroom session brings another unusual case into focus. An individual has appeared before the court after failing to meet the conditions set during an earlier ruling. Rather than choosing standard legal assistance, she has elected to speak on her own behalf, a decision that often adds unexpected turns of proceedings. What quickly stands out is her approach. The arguments presented do not sound spontaneous or personal. Instead, they resemble prepared lines, repeated word for word, as if taken directly from a guide rather than formed from genuine understanding. This raises an important question about whether these claims are truly believed or simply used as a last attempt to avoid consequences. From a judicial perspective, courts rely on facts, lawful reasoning, and accountability. Pre-written arguments that reject established legal principles rarely change outcomes and often complicate matters further. Judges have seen these tactics many times before, and the results are usually predictable. I'm curious to hear your thoughts. Do you believe this is a sincere belief system, or is it a strategy used when options feel limited? Share your opinion in the comments. If you find courtroom breakdowns and legal commentary like this useful, make sure to support the channel and stay tuned as we take a closer look at how this case unfolds.
Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this myself.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one. You qualified. You do have the right to represent yourself as well, and that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence just as if you're an attorney. You understand that?
Yes, sir.
All right. Does anyone promise you anything or threaten with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab him real quick.
Okay. Okay, state has the burden. Any opening statement, Mr. Marcinski?
No, sir. Thank you.
All right, Ms. Clark, any opening statement?
At this point, any opportunity for a strong legal defense appears to be slipping away. What's noticeable is the absence of familiar arguments often heard in similar cases. Claims about authority, jurisdiction, or personal exemption from established law. Whether intentional or not, avoiding those statements may actually prevent the situation from becoming even more complicated. However, choosing not to present an opening statement is a serious misstep, especially for someone speaking on their own behalf. The opening is not a formality. It's the moment where a defendant explains their position, outlines their reasoning, and frames how the court should view the case. Skipping it leaves a judge with no context and no explanation. Silence in this setting does not work in your favor. When no argument is offered, it can easily be interpreted as a lack of preparation or a lack of defense altogether. Representing yourself requires effort, clarity, and engagement. And without those, the outcome often becomes predictable. I'm interested to hear your thoughts at this stage. Do you see this as a strategic choice or simply a missed opportunity? Share your perspective below, and let's continue examining how this courtroom moment unfolds.
First witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes,
And what was the result of that UA sample from Miss Clark?
it was positive for methamphetamine.
So her UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines?
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No.
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
Yes, and I did. I received that, and apparently she has new charges.
To your knowledge or to the notes, did Miss Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No.
All right, do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right, Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now, I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
No.
Does anyone else feel a sense of discomfort watching this unfold? While the case itself is serious, seeing someone struggle publicly in a courtroom can be difficult to watch. Court proceedings are formal and unforgiving, and when a person is clearly unprepared, the moment can feel heavy rather than satisfying. That said, it's also hard to overlook the choices being made. Professional legal help is available, seated right beside her, offered at no personal cost. The attorney remained composed, attentive, and ready to guide the process. Yet that assistance was deliberately declined. Decisions like that often shift how much understanding people are willing to offer. What continues to puzzle many observers is why individuals following these beliefs reject support that could genuinely protect their rights. The legal system has established pathways designed to help defendants explain their position clearly and fairly. Turning away from those resources usually leads to outcomes that could have been avoided. I'm curious where you stand. Do you feel compassion for someone navigating the situation alone? Or do you believe the result reflects the decisions made along the way? Share your thoughts below as we return to Courtroom, where a critical moment in this case is approaching.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument?
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence, take her into custody.
All right. $1,200 every.
A claim like demanding payment for time spent in custody immediately raises eyebrows. The idea that someone should be compensated after failing to follow court order conditions shows a deep misunderstanding of how the justice system works. Court supervision is not optional, and consequences are not negotiable. What makes the situation more serious is the broader context. Violating court orders while placing a dependent at risk shifts this case far beyond technical errors or paperwork disputes. At that point, the court's responsibility is public safety and accountability, not entertaining financial demands or symbolic arguments. Comments made toward the bench also matter. Courtrooms operate on respect and procedure, and remarks that challenge authority or dismiss the process rarely help a defendant's position. Judges are tasked with enforcing the law, not debating theories about personal exemption or imagined compensation. The belief that rejecting legal authority somehow creates entitlement to money has no grounding in reality. The court is not causing harm here. It is responding to actions that have already occurred. This is not about punishment for beliefs. It is about consequences for conduct that I'm interested in hearing your perspective. Do you think these claims are sincere misunderstandings or simply last-minute attempts to avoid responsibility? Share your thoughts below. And if you follow courtroom analysis like this, be sure to stay connected as we continue breaking down what happens next.